A former daycare worker and her male accomplice are accused of some of the most heinous crimes possible involving children. And prosecutors say their excuse was that they were drunk. We're breaking down this disturbing case with criminal defense attorney and former prosecutor Matt Mangino. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Now, as you can imagine, this story is very upsetting, so I want to give everybody that warning before we get into this. But what we're talking about is a former daycare worker, 24-year-old Morgan Rothenhoefer, and her reported boyfriend, male accomplice, 42-year-old Jamie Souders. They are accused of not only perpetrating horrific child abuse, but filming it. They each face a slew of felony charges in Middlesex Township, Pennsylvania. And this week, they both waived their preliminary hearings. Arraignment is scheduled for November. Souders filmed an 8-year-old child performing sex acts on Rothenhoefer back in February. Now, here is the long list of charges that Rothenhoefer faces, and they're all felonies: rape of a child, aggravated indecent assault, involuntary deviant sexual intercourse with a child, 5 counts of knowingly filming, photographing, or depicting a child in a sex act, corruption of minors. Souders faces the same charges, but as additional counts of child pornography and criminal use of a communication facility. We'll talk about this more, but as you can imagine, if they are convicted across the board, more likely than not, they probably will never see the light of day again. So investigators say how this all happened, how they became aware of this. This is interesting. They were contacted allegedly by a cloud data storage company with a tip about possible criminal sexual abuse material. It's also known as CSAM, and that was linked to Souders. This is according to court documents. Now, while multiple children are believed to have been victimized by Souders' possession of CSAM, the couple is only charged in connection with assault on one child, as of right now, I should say. Now, according to court documents, Souders basically confessed, acknowledged to police that they would find CSAM on his electronic devices, that he was sexually attracted to naked children, that he knew what he did was wrong, that he had a pornography addiction. Pennsylvania State Police say that Souders used the cloud service Synchronos to record, download, and upload child sexual abuse material. In terms of Rothenhoefer, Souders apparently said he had known her for years. Rothenhoefer reportedly told police that she had known Souders since she was 14, but he said that he's known her for 15 years total, which would, if that's true, would make her, what, just 9? So if this is true, this kind of adds a new layer to this alleged child abuse story and understanding the potential context and history between the two. But both Souders and Rothenhoefer reportedly told police that they couldn't remember exactly what happened during this incident involving the 8-year-old, which was filmed. They said that they were drunk or under the influence of drugs at the time. Rothenhoefer reportedly told police that she was, quote, very drunk and on cocaine and Adderall at the time of the recordings. Police say they found CSAM on Souders' electronics that dates back to at least 2006, and noted they even found photos of young girls in bikinis that had been printed out and framed in his home. Court documents state that police could tell the abuse of the 8-year-old happened inside of Souders' house. And if you thought that this couldn't get worse, let me circle back to something I mentioned before, that Rothenhoefer was recently employed at a daycare and preschool center in Silver Spring Township called Tender Years. Now, attorneys for Tender Years say that the 24-year-old was hired on August 7th after she apparently passed all government-mandated criminal background checks. A letter sent out to parents introduced Rothenhoefer as a first-year preschool teacher. She wrote that she had 5 years' experience nannying and working in other daycares. When administrators learned about the charges against Rothenhoefer on September 12th, they immediately fired her. And to be clear, they are saying that these allegations happened before she was employed by them. Yeah, according to a statement from Tender Years' legal counsel, it says, quote, "We have been advised by law enforcement that all alleged actions related to the criminal charges occurred in February and or March of 2024 before her employment at Tender Years and does not involve any children under the care of Tender Years." The center also says that for the few weeks she was working at Tender Years, that she was always in a co-teaching situation, never working alone with any children. At first, the pair were denied bond, but now a bond has been set for both. $1 million for Souders, $750,000 for Rothenhoefer. I want to bring on right now attorney and former prosecutor in Pennsylvania, Matt Mangino, to talk more about this. Matt, thanks so much for coming on. Your reaction to this? Is this something that you've, unfortunately seen before?
Yeah, unfortunately, this is a horrific case. I mean, there's no two ways about it. I mean, it's the facts are outrageous, but unfortunately, this is not, an anomaly. This is something occasionally that happens, and that we see frequently, both as a prosecutor and as a defense attorney. The charges are extremely serious, and that's appropriate based on the facts as we understand them.
And to be clear, if they're convicted, would it essentially be a life sentence? Because correct me if I'm wrong, if you talk about rape of a child who's under 13, I thought that's 40 years in prison. That's a potential maximum of 40. Correct me if I'm wrong on the law on that, but what are they looking at potentially?
Well, you're correct, Jesse. The rape of a child has a statutory sentence of 20 to 40 years. So Pennsylvania is an indeterminate sentencing state. So the max, you have a max and you have a minimum. And so on that charge alone, it would be 20 to 40 years. If you were convicted of all of these charges, IDSI involving a child rape, all the charges that go along with it, indecent sexual assault, if you add these up consecutively, one sentence after the other, which a judge would have the right to do if there was a conviction. I mean, you'd be looking at, sort of a de facto life sentence. You can't necessarily, you can't get a life sentence on these charges,
right?
But when you add these charges up,
what would be the likelihood that a judge would have them run one after the other in a case as disgusting as this? And by the way, there could be additional charges,
Right. As I understand, there are other potential victims. The matter is still under investigation. This is a area, Cumberland County in central Pennsylvania, a somewhat conservative county. So you're looking at a judge here and a prosecutor who is going to look at this, very seriously. And, I wouldn't be surprised, especially if there were a trial in this case, that you could see maximum sentence consecutive to one another. But again, I'm sure that there's going to be some effort to mitigate that. As you said, Souders has already acknowledged or admitted this activity. So you might be looking at a plea ultimately.
Hey, so I'm going to take a guess and say that a lot of you who watch Sidebar might be business owners, maybe even thinking of starting a little side hustle. Well, if that's the case, I want to talk to you about our amazing sponsor, Odoo. So Odoo is a free all-in-one business management software that provides you with a range of applications that helps with the day-to-day of owning a business. Now, as some of you might know, I'm the host and executive producer of a very popular YouTube show called Prime Crime. It's on our Law&Crime page. So this is like managing a business, and I want you to watch this. Say if we ever charge for Prime Crime, and to be clear, we have no plans to do that, so don't worry, I could seamlessly and for free build a Prime Crime website with Odoo and put a built-in checkout page on the website with very little effort. Monthly subscriptions, it's even easier. Look how easy that was. 5 minutes later, I now have primecrime.com. So thank you to Odoo for sponsoring Sidebar, and thank you for getting me a Prime Crime website. You can build your website now. Domain is free for the first year when you use our link odoo.com/LC Sidebar. Well, he seemed to have admitted to possession of the illicit materials, let's just call it that. That in and of itself, what could he be looking at? Because if you're talking about a deal, let's break this down a couple of ways. First of all, if he's allegedly admitted to being in possession of this material, and I think that's really hard to defend in general. It's one of those cases. If it's on your computer, it's traced back to you. I don't know what much of defense, let alone if he admitted that was his material. That itself, what could he be facing?
Well, that's a very serious charge in Pennsylvania, the child pornography charge. And, what you would look at essentially for a first offender is the sentence guidelines. So you're going to look at his prior record and where that ends up. and you're going to look at the offense gravity score, which is very high. And there's basically a graph that would tell you here is the range of sentences. The interesting thing about this statute, though, is if you're a second offender, if this is your second offense with child pornography, it's a 25 to 50 year max mandatory sentence. So that gives you an idea of just how serious these charges are.
And the fact that there's so much material on there allegedly dating back from 2006. One of the things that is very interesting is that you had this cloud data storage company who reached out to law enforcement. And my two questions are, A, how come this wasn't detected earlier? And B, is that common? Do you see these kind of companies reaching out when they discover this material on their platform? And I imagine this happens more often than not, that they alert authorities to this, but you tell me.
Yeah, it's not unusual, for law enforcement to be tipped off by, someone who is involved in, the way this information is disseminated. The other thing is, a lot of times what you have are troopers, Pennsylvania State police officers, or attorney general agents who are posing online as individuals who want access to child pornography, and then there's the transfer of the child pornogaphy to them. So these charges are typically done either by investigation, using a sort of an informant who's online posing as somebody else, or being provided that information by other sources.
But how come it wasn't discovered sooner, right? If there's stuff from 2006. I mean, look, data's changed, but I don't know.
Well, I think, what we'd have to do is look at how they first discovered it. So I would assume they discovered it because of some effort to transfer, to put it online so other people could have access to it. Then what might have happened is they went back, they looked at his computer, they looked at his cell phone, and they found all this other information that he had stored there, maybe not disseminated, but had stored for an extended period of time.
Right, that makes sense. You mentioned a deal. I don't know what a deal would look like. I mean, based on these allegations, based on the fact that there could be more people that come forward, it seems, I mean, from my perspective, it could be difficult for me to believe this is the only person, this 8-year-old is the only one who might have actually been physically abused by this pair, maybe. But what would a deal actually look like for two people who are accused of these crimes?
Well, again, the first thing would be to look at their history. Not only the history of dating back to 2006, with information, and I think, unfortunately, what we're probably going to find is some history between,
Souders and Rothenhoefer. Yeah. I was going to ask you about that. Yeah.
Right, because she's claiming she's known him since she was 9 years old. That there may be a history there, which
Right.
really entangles their cases even further, because she becomes a victim herself as well as being a perpetrator. But I think what you look at is the history of their activity, their history in the criminal justice system. And then, obviously we know just how serious these charges are. It's not a matter of having to bring victims in to testify, because what you have is videotape. You have this information. So that makes it even less likely that the prosecution is going to say, hey, we want to save the witnesses from having to be involved in this, so we're going to try to work out a deal. I don't think you need them, because you have all this documentation provided by the defendants themselves. So I think any plea agreement is going to be a tough, long sentence, but it is a possibility, based on the fact that he's already admitted. But as we know, Jesse, and you've seen so many of these trials, sometimes when the prosecution is in an extremely strong position, they say, hey, you're going to take the max on everything, or we're going to go to trial.
Right.
So sometimes cases they go to trial because they're not good cases and the defense wants to go to trial, but sometimes they go to trial because they're good cases and the prosecution wants to hammer somebody.
That's a really good point, because if they don't even have to bring in like this it's not going to be 8 years old anymore, but if you have to bring in this child essentially for, to testify, if you could say we have enough here, then you take away one of the hesitations that the prosecution would have had. That would have been, if they're like, look, we really don't want to have to go to trial, but if we can't work out a deal here, we have no choice. They're like, listen, we don't have to have this 8-year-old testify. But I will also tell you that this would be an incredibly difficult trial to prosecute, not in the sense that it's tough to prove, but to have a jury sit through this. And even if that child or the child's parents or the family or friends are not in that courtroom, the idea that that video is being played in a courtroom for a jury, that could be painful. I would imagine prosecutors want to avoid a trial, given what they're dealing with here. So I wouldn't be surprised. But I agree with you. I don't think that they're getting off the hook. I think that they would be facing significant prison time. But in terms of a defense, the child pornography charges, you put that to the side, it looks like he, again, seemingly admitted to it. But where they're talking about, we don't even know what happened with the 8-year-old. There was drugs, there was alcohol. Whether it's Souders, whether it's Rothenhoefer, that can't be a defense, right?
Well, no, Jesse. Voluntary intoxication is not a defense, to criminal activity. It could possibly be some sort of mitigator when it comes times for sentencing or things like that, but it doesn't relieve you of your responsibility, not to commit crime. So the mere fact that you got drunk or you got high is not a defense to the criminal conduct that you're involved in.
Sure, but what if, and the reason I say this is we talked about the alleged history between these two. He has a higher bond than her. It seems to me he's facing, I think it'd be fair to say, more charges than her. You could make the argument that he's maybe more culpable than her, although she is charged as being an active participant. But if she crafted an argument that she was manipulated, she was coerced by this guy, she was forced to take drugs and alcohol, that would be the only kind of fact scenario that might work for her, right?
Well, as we said a bit earlier, this dynamic here is going to be closely scrutinized. Okay, because if he and this is hypothetical, of course, we're just throwing this
Sure.
out there, but
Yep.
if he was grooming her when she was 9 years old and he was sexually abusing her when she was, a young teenager, and he had consistently throughout her youth provided her with alcohol and drugs so that he could sexually assault her. So he's groomed her into this sort of functioning person that is involved with his outrageous ideas about sexual relationships and children, things like that. So yeah, I mean, I think she could raise those issues in her own defense, that she's been manipulated, she's been abused herself, he influenced her in this conduct because of this long history. So yeah, I mean, I could see that being something that's raised by her. Certainly doesn't do anything to help him. He's
Right.
it's even worse for him.
And by the way, again, just to re-emphasize this once again, we have no evidence of that. We do not know if that's true. We're hypothetically speaking from a legal point of view about how that could potentially be a defense. Why do you think they waived the preliminary hearings?
Well, that's a good question. I mean, the preliminary hearing in Pennsylvania, it's the probable cause hearing. I practice criminal law in Pennsylvania. I am reluctant to waive preliminary hearings. I think they're the most important part of a case. But, there might already be discussions in this case about, the way forward in terms of resolving it. If you have any inclination at all about going to trial, you need to have a preliminary hearing.
And by the way, a preliminary hearing is where the prosecution would present evidence to say that there is enough probable cause to move forward. Difficult preliminary hearing because this evidence would be exposed.
Yes, it would be, but I think, at least in my experience with regard to preliminary hearings, they're very early. They're within 10 days of an arrest. It's a good tactic as a defense attorney to have a preliminary hearing to cross-examine any potential witnesses, police officers, at this very early stage of the case. Here, this might be an indication that they're already working on trying to resolve this case because they've waived the preliminary hearing.
Before I let you go, one final question about tender years, this daycare and preschool center. They've indicated that as soon as they found this out, they fired her, that this alleged criminal conduct predated her time with them, that she was always supervised, seemingly passed all these government background checks. I guess the question is, do they face any liability whatsoever? And B, I think it would be fair to, like, would any of, I guess if this wasn't discovered, this wouldn't have popped up on a background check. So it's not surprising that she was cleared, right? And B, do they face any kind of liability?
Well, I don't think, based on what we know right now, that they would face any liability. They're going to do their due diligence. They're going to make sure that you have a child abuse clearance, a criminal background check, FBI check. All these things are typically done in Pennsylvania with regard to anybody who has contact with children, whether it's a teacher, a coach, a daycare center worker. I think what Tender Years is probably going to want to do, and probably already has, is notified all the families about this employee, and they're going to look into any potential impropriety that occurred from August 7th, I think, until September 12th, when she was terminated. At least what we know at this point is that it doesn't appear that there's anything wrong, and I don't think that the Tender Years has any problem, unless, of course, there was some sort of abuse that occurred there, and there's no indication of that.
Matt Mangino, thank you for coming on, talking about this difficult case. Love your expertise. Love you sharing your experiences with us, and particularly in that jurisdiction. You know how it goes. So thank you so much. Appreciate it, sir.
Thank you, Jesse. I enjoyed it.
All right, everybody. That's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.